It was a private conversation.
Oh, yeah. You have a private conversation in front of
It's all being recorded anyway.
No.
And we have been told, whatever you talk about pre-class, just know it's being recorded before you ever get started.
Pretty funny.
So.
We're just talking about you guys in the next one. We're just talking about you in the next one. And how well everyone is doing. That was our state of mind.
Ah.
Present sense of information.
If you guys will hurry up and graduate and become lawyers, I had dinner last night with what I will call a colleague of mine who actually is a CDTA graduate.
All right.
And we went and we had dinner and beers and talked about the law. And
So you want us to graduate so we can become lawyers so we can take you to dinner?
Yes.
yes. Yeah, just so you know, I paid and he took the extra pizza home.
Okay. This has to be.
What's wrong with this picture? But yeah, it was a really neat experience, you know, sitting down with somebody who used to be where you guys are and hearing them talk about the law and their cases and how that, you know, is, it was really neat.
That narrows it down.
Hmm?
So he or she.
It was a he. It was a he. He practiced family law with it was not Mike,
No.
with a certain very prominent family law attorney, you know, who used to also be a professor here.
Used to?
Yeah. She used to.
Now, is she retiring already?
What
I
I learned
know.
last night is she's retiring probably 2 years out.
Oh, okay.
Yeah.
It's Sheila Adams.
No, that's not retiring.
Anthony.
Anthony.
Yes.
I know him though, he's really nice.
Oh, good guy.
Yeah.
Now I saw Brian. I saw him roaming around out there.
He's out busier.
So I gotta ask, is Los Angeles just like the city of losers now, or?
You know, I've been dealing with this for a couple of days now. You know, that was just a brutal game.
It was horrible to watch.
Yeah, I mean, if you had told me, you know what, New England's going to score 13 points, like,
They're gonna get killed.
we're champions, right? If our defense holds them to 13 points, we're champions. That's simple. And yeah, you guys may be lucky if you even score. And that was just a horrible, horrible game. And, you know,
I got Super Bowl squares, and I was really angry when the numbers were picked for them because I got 0-0 and 3-3.
That actually worked pretty well, didn't it?
Yeah, I hit 3 out of 4 squares, so I won like $375 on $20 I threw.
Wait. He didn't just admit to illegal
I
gambling.
think you said you got some friendship points. You got a lot of friendship points?
Right.
Yeah. Oh man, I was in my friendship squares. I was never even close. You know how sometimes you get there, it's like, okay, if they kick a field goal, come on, get a goal, kick a field goal. Like, I was never even anywhere in the ballpark.
If they block the extra point and run it back for a score,
Yeah.
they might have a chance.
Yeah. I got a bunch of nothing on my
So I was doing that the Super Bowl day, and it was working for me. I was like, all we need is a stop here by the Rams. I want the Rams to come up with a stop, and then they did.
Mhm.
Likewise with Patriots. Patriots need to come up with a stop here, and they did.
They did a lot.
Yeah, that
The
was.
highlight of the game is a 65-yard punt.
Yeah. That and Robert Kraft and Tom Brady kissing each other on the lips.
Not that there's anything wrong with it.
Not that there's anything wrong with it, but it's like, can you do that? Like
Apparently you can.
that's like a sexual assault or something? I don't know.
Not if it's not unwelcome, it's okay.
Okay, hearsay. we're
Still talking about hearsay.
we're having some fun tonight,
No.
right?
Yes.
Because
Yes.
we've right, we're moving right along. So we have hearsay, and our first analysis that we're going to do is it actually hearsay? Does it meet the definitional components of hearsay? Is it an assertion? Is it there a declarant? Is it offered for the truth? And assuming you come out of that with, yeah, it's an out-of-court assertion being offered for the truth, then you got to go to
Is there an exception?
exclusions.
Exclusions for,
Are there exclusions? Right? And you've got your 3 witness exclusions, right? They're on the witness stand, subject to cross-examination, and if they've offered a statement under oath at trial that is inconsistent with something they have offered under oath in a different proceeding, that inconsistent statement is not hearsay. It's excluded from the hearsay rule, and it can come in. And if they are on the witness stand and they get challenged over their testimony, you just made that up right now, right? It's been recently fabricated. You never said that before to anybody. And in fact, you have that consistent statement that you made, not under oath, not at a prior proceeding, right? To anybody can come in to refute that claim of recent fabrication and motive to lie. And then, of course, if you are on the witness stand and you're being asked to identify somebody and you have identified them in the past, the court recognizes that those prior identifications are probably the most valid because they are closer in time to the event that you identified them for. Those prior identifications come in as non-hearsay. Even though they're out-of-court statements being offered for the truth, the statute has excluded them from hearsay. And then you got the whole laundry list of party opponent statements, admissions, and adoptive admissions, and authorized statements, and within the scope of employment statements, and co-conspirator statements, right? And so you have that whole analysis you've got to do there. So if you come out of there and you're like, well, nope, it meets the definitional rule of hearsay, it's not excluded from hearsay by statute, then you go into the world of, are there any exceptions?
And man, are there a lot of exceptions.
A bunch. So you should have no problem finding them. The key to our different type of exceptions is they're broken down by type. Okay, you've got your, what we're going to go through tonight are basically a laundry list of what the law categorizes as spontaneous or contemporaneous type statements that you're making right there on the spot. This does not require that the declarant be available or unavailable. Doesn't matter. The rule doesn't go that way. So if you've got an exception and that witness is sitting in the audience, doesn't matter. You can still ask the person on the stand that question, and if you got an exception, it comes in. If You got that witness on the stand, and the person who made the statement, you have no idea where they are. You can't find them. You can't put a subpoena in their hands. Still doesn't matter. Right? The law doesn't require that. And the reason it doesn't require that is because all of the ones that we're going to talk about tonight, the courts have deemed trustworthy and reliable. And they find them trustworthy because the circumstances under which they were made lend them that trustworthiness. So much so that the courts have said cross-examination, no matter how good the advocate is, your cross-examination is not going to undercut the reliability of these statements. So we don't even care if the witness is there and on the stand or not. We'll get to exceptions that matters. But for these statements, it doesn't even matter. That's what the courts have said, and that's what the legislatures have followed up with and enacted. And they might call them different things, but the underlying rationale for all of these are the circumstances under which they were made lend credibility to them because they're given at a time and during an event in such a way that you wouldn't expect somebody to be making it up. They wouldn't have time to make it up. The way in which they're making the statement shows that they're acting under the stress of the event. And so, before we get into some of the problems, let's just take a look at each of the different rules that we have. 803, 1 through 4 are what are collectively referred to as spontaneous statements, spontaneous declarations. Okay, and even though there's only 4 subsections, right, the rules basically give us 5 different exceptions. So why don't we start off with 803.1, and if I can get to my page, and then we'll take a look at it. All right, 803.1, called a present sense impression. And basically it's a statement describing or explaining an event, condition, made while or immediately after the declarant perceived it. Okay? So basically you are describing something as you are perceiving. Excited utterances are 803.2, a statement that relates to a startling event or condition that's made while the declarant is still under the stress of that excitement. So if you just look at the timing of these, right, the present sense impression says you are describing an event or condition while it is happening or immediately after you perceived it. Limited in scope as to timing. Excited utterances, it's a statement regarding a startling event while you're under the stress of that. Well, how long are you under the stress of that? That's 5 minutes, 10 minutes, an hour, 2 hours? Well, that's a factual determination for the courts to determine. Can you be acting under the stress of something, longer than immediately after you perceived it? Of course. So this is a broader, from a timing component, but more limited. Present sense impression deals with any event or condition that you perceive. Excited utterance only deals with startling events or conditions. 3 is really broken down into 2 things. Statements of your then existing mental, emotional, or physical condition. A statement of the declarant's then existing state of mind, such as motive, intent, plan, or emotional, sensory, or physical condition, such as mental feeling, pain, or bodily health, but not including a statement of memory or belief to prove the fact remembered or believed, unless it relates to the validity of the terms of the declarant's will. And so we'll see problems to that. But basically, this is you're talking about your mental or emotional state. I'm mad, I'm angry, I'm, nervous, or your physical state. My arm hurts, my leg hurts, and you're talking about it right now.
As you're experiencing.
As you're experiencing.
I can't breathe.
Okay. And then 4 is pretty straightforward. A statement that you're making for the purpose of medical diagnosis. Okay.
And notice that this doesn't have to be, you don't have to be upset. You don't have to be sensing it right then. You just have to be telling it to a healthcare provider.
Right. And the theory behind that is if you want to get good medical treatment, don't lie to your doctor.
As a practical matter, seriously, a lot of people, a lot of us lie to our doctors. But the theory is you won't lie to your doctor.
Right.
Notice that there is an exception for seeking legal advice. Because everybody knows people lie to their lawyers.
So if you go right to 14, well, first thing, let's take a look at page 549. Okay. At the bottom there of 549, it gives you the statutory elements that you need for a present sense impression and an excited utterance. Okay, those are your elements. So for exam taking purposes, right, it meets the definition of hearsay. It's not excluded. I think it's a present sense impression. For a present sense impression, I've got to prove 2 things. The declarant made the statement while or immediately after perceiving an event or condition, and 2, that the statement actually does describe or explain the event or condition. You do your analysis. This qualifies as a present sense impression. I would let this in under this exception, right? So it's an elemental analysis. And when you were dealing with the excited utterance, it's the same thing, right? It's got those 2 elements that we need to take a look at. So if we take a look at 14-2, and we'll jump in. And we'll see how these things play out. Okay. Who wants to just get in and get their friendship points for the night bright and early and be done with it?
I guess I'll do that.
Okay.
Done friendship squares before, so. Might as well. All right, so Denise, a pedestrian, sues Steve for injuries resulting from being struck in a hit and run, allegedly by Steve's red car. Steve's defense is that Denise was actually struck by a blue car that passed Steve's car shortly before the mishap. Marissa, an ambulance driver, arrived at the accident scene 10 minutes after Denise was struck. To prove that Denise was struck by a red car, her attorney calls Marissa, whose testimony is as follows. Plaintiff's attorney. Marissa, what did you see when you arrived at the scene of the accident? Denise was laying on the ground. A few people were standing around her. What did you notice about Denise? She appeared to be in great pain. She was writhing around, yelling out and crying. Then what happened? I knelt down to do a quick check on her condition. I tried to comfort her, telling her, you'll be okay, you'll be okay. Then I asked her where she was feeling pain. Did Denise respond to you? Yes, right after I started saying this, she said, I hurt so bad, especially my legs and my back. That red car hit me right after I stepped onto the street. Objection, hearsay. From the plaintiff's description of how she was hit, I'm dubious about her claim that she saw the color of the car that hit her. I'm leaning toward excluding the last sentence on that ground. Is this a legitimate basis for a ruling? Well, the last sentence is that red car hit me right after I stepped on the street. It could be immediately after,
Okay,
correct?
right, so what might that be? A spontaneous statement? Present sense?
Yeah, present
impression?
sense impression, yeah.
Like, she
Because it
just
could be-
saw the red car, except what do we know when the ambulance got there? How long after the accident did the ambulance get there?
About 10 minutes after?
Okay, so it's 10 minutes immediately after she saw the red car? What do you think?
No.
It's kind of stretching immediately, right?
Yeah.
But don't give up, right? Just because the red car isn't, maybe doesn't get in as a present citizen. And by the way, I wouldn't give up on that either. I'd say, oh, come on, right? I mean, it's practically short, you know.
Well, wait, I'm confused on why we're talking about the ambulance because I thought it was just the last sentence that we're talking about. That red car hit me right after I stepped on the
Right,
street.
and who's the witness?
Oh, the ambulance.
Yeah.
driver. Okay.
So the ambulance driver couldn't have heard it for 10
Yeah, they
minutes.
got 10 minutes after, okay.
Okay, so maybe present sense impression, but we got a problem with the immediately after she saw the red car. But what else have we got? Number 2,
Excited utterance.
right? Is she still under the stress or excitement of getting hit by the red car?
Yeah, if your adrenaline's.
Damn right.
Mhm.
She's on the ground. She's in a lot of pain. It'd be hard to say she's not, which means
That this is getting in.
it gets in.
Now let's take a look at the first part,
Which we didn't ask about.
and 'cause I want you guys to see something, okay? The first part, she said, I hurt so bad, especially my legs and my back. Is that a present sense impression,
Yeah, this is happening while she's proceeding it.
right? Is it an excited utterance?
Yes.
Is it a statement of her then existing physical condition?
Yep.
Yep. So it meets all three.
Is it a statement being made for the purposes of medical diagnosis and treatment?
Yep.
You see that? Right, that first part comes in every way. So, for test-taking purposes, it is not a good response to say, if you just had that first portion, this meets a present sense impression, I would let it in.
Or it's a statement of then existing physical condition, right?
Right.
You want to hit all the ways you can.
All the ways that you can identify that it comes in is going to show us you know these rules and you know how they apply, right? If you just jump the first one, right, nothing's changed, right? If you go in and you say, well, this isn't offered for the truth, I wouldn't let it in, and that ends your analysis, that's not a good analysis, right? But if you come through and then you jump at the very first exception that you think it meets, what if you say present sense impression and the court says, nah, I don't think so. Right.
Well, how about? Right.
Right? So,
I have a question. For test taking purposes, you want us to say if it doesn't meet, we start out with the definition of the rule statement of hearsay. And if it doesn't meet that definition and it can get in still to go on to the exclusions and everything else about all of the, pretty much talk about every single way we could
It's
get
sort of
in.
a yay more. Say, even if it wasn't, or even if it wasn't already admissible, here's another way it could be admissible.
yeah,
And by the way, if you get something like this on the multi-state and a multiple choice, whatever, it's kind of, the way they always do it. 2 sort of right answers and 2 sort of wrong answers. And what you may have to pick is like, what's the better argument, right? Well, the best argument here is it's a statement of then existing physical condition, right? But that doesn't mean that there's not another, and there may be more than one way to get it, but just be aware that sometimes you're gonna have to like say, which is the best argument for getting it?
so, and then if you look at the second part, right, I kind of want you guys getting in the habits of how would you respond to this, right? If the judge told you, look, you know, that whole thing about the color of the car when she was hit, I'm dubious that she even saw that color of the car. I think I'm going to exclude that last sentence, right? Your response should be, go.
I'm sorry, I was reading ahead, I wasn't paying attention to you.
Okay. Well, the judge says, look, I don't think she could even see that car. I'm dubious about, that last sentence. I'm leaning towards excluding it.
Okay, then you fall back on the definition of one of the exclusions.
Right.
You're saying that the testimony isn't gonna be considered, right?
I would fall back on your exception, which you've already done, right? You've identified that this is an excited utterance, and it's an excited utterance because she's been in a startling event, and she's making the statement about the startling event while she's still under distress. And Your Honor, the whole, underlying policy for this exception is that the circumstances under which it was made is what gives it its credibility. So you questioning the credibility isn't an appropriate basis for excluding the statement, right? It's the circumstances under which it was made which gives it its trustworthiness. Okay, so I want you to understand that. And you're going to have to feel it out, right? You don't want to call the judge out in front of the jury and make them look bad, but you want to let them know that, oh, wait a second, this is trustworthy. I understand the courts, said that it's dubious about it, but it's exactly the way in which this statement came out is why it's trustworthy and we should let it in, aside from you meeting the statutory elements. So that's why having an understanding of why each of these exceptions are in place gives you the ability to more effectively argue for its admittance.
Okay, I see what you're saying.
Okay?
I just assumed that if the judge is ignoring the credibility, that he's pretty much ruling that the testimony or that this wasn't said at all. So how else do you get the statement in?
But this is how you argue that.
Right.
Look, I understand, Your Honor, think you've got a concern about personal knowledge or whatever, but this exception to the hearsay rule is founded on the idea that the statement's reliable. That's why the exception exists. Yeah. But you're right. If you're not persuading the judge, you got to figure something out.
All right, plaintiff's attorney, what happened next? My partner and I got Denise stabilized and we put her in the ambulance to take her to the emergency room. Were there other people nearby at the time you were stabilizing Denise? Yes, maybe 5 or 6 people. Did you hear any conversation between any of these people? Yes, I heard one person ask what happened. Another person said that a pedestrian was hit by a red car and that the driver of the red car drove off without stopping. Do you know which 2 individuals had this conversation? I don't. I was focused on helping Denise. I object and move to strike the unknown onlooker's remark, hearsay. I also ask that Your Honor instruct the jury to disregard that testimony.
So identify your statement.
So here there's multiple statements. So do you have to analyze each statement, because you said I heard one person ask what happened. That's one
Okay,
statement.
so is that hearsay?
Yeah, it's not a court statement.
It's
an
a question, right?
assertion.
Oh,
So it probably isn't hearsay. It's not even something that could be true or not, right? It's a, hey, what's going on?
right.
So probably not hearsay. But the response is clearly offered for the truth, right?
Yeah.
Red car, driver fled, all that. So how might we get that in? Since the other side has objected and moved to strike it.
Just go down your list.
Yeah,
Present
an
sense
event or,
impression?
yeah, it could be an event or, yeah, it could be an event, right? So present sense impression. Because I don't think it would fall under anything else. It would be excited utterance.
Well,
And under present sense impression, was it made at the time it was perceived or immediately thereafter?
Immediately thereafter.
Yeah.
Right after.
and you got your same 10-minute problem, right?
Yeah.
About whether that's
That's
10
immediate or
minutes,
not.
but yeah.
Right, that's the problem. That's the problem that you gotta deal with is, right, if that conversation happens right after the accident, clearly it's immediately after the perception, right? But arguably this is happening at least 10 minutes after the accident, probably closer to 15. Taking a look at everything that's happened. So does 15 minutes qualify as immediately thereafter?
Stretching it a little bit.
Stretching it,
Oh,
yeah.
yeah.
Well, when we're talking about immediately thereafter, you're probably talking 1 to 2 minutes tops.
Long enough for you to say, oh, shit.
Yeah, yeah, and then just, yeah, you're really stretching it to say they said that 10 minutes after. So, is it an exciting?
What else? Excited utterance?
Yeah, because the declarant could be perceived to be under stress and kind of heat of the moment. and-
Just saw an accident,
An
guy
accident, yeah.
flee, right? Except we don't really know,
And they just stabilized her.
because they haven't told us whether the guy that made the statement was upset about it, about what happened, or still excited about it or what. But you might argue from the,
And that-
if you had the chance to develop it, you say, well, did you hear the tone of voice of the person that, made that statement about the car? Yeah, it was, the person was like really intense, and they were short of breath, and they were, clearly really upset about it. They sounded stressed. They were.
But when you're looking for that, you're gonna need facts to demonstrate that they're under the stress of the event. Okay? And all of those things that you would expect, that is I just told you, right? If you don't have that, does that mean that they're not under the stress? Right? Maybe they're in shock. Maybe that's why they're acting so calm under the face of, wait, this just happened, right? But you've got to convince the court that it is under the.
Anybody see that Tom Hanks movie from the mid-'80s, Bachelor Party? No, of course not. Well, anyway, there's one scene where the soon-to-be son-in-law, Tom Hanks, the girls are like gonna get even with the guys for having this bachelor party with strippers and everything. So they are gonna go like to Chippendales or whatever. Anyway, the bride's mother, they play a practical joke on her, and she ends up grabbing what she thinks is a hot dog, but it isn't. And she's like, and she's in this really flat affect saying, a strange wind in my hand. Okay, that she's clearly under the stress of the incident, but she's not like yelling, screaming, anything, but she's clearly under stress of the incident, and she's describing it, right? I'm sorry, it's the best illustration I can come up with to illustrate what Professor Nolan just said, which is, you can be stressed out, you can be acting under the stress of the incident and describing it, but be totally like really flat affect because you can't believe what just happened.
But you've got to be able to make that argument. Why it is, if you want it in, why it is you think it's an excited utterance.
And of course, who's got the burden of showing it's admissible? Whoever's trying to get it in.
Yeah.
Right?
So let me just give you an example so you can kind of see how this kind of plays out. Okay? You got two neighbors, they're walking down the street. They hear 5 gunshots, right? Mary, what was that noise? Zariah, Sounded like gunshots. Where did it come from? Sounded like it came from the Smith's house. Do they own guns? I thought they were Democrats. No, when we were at their house for dinner, I think I remember Joe saying he went to the gun range on the weekends. Should we call the police? You call. I don't want to get involved. Right? So somewhere between hearing gunshots, what's that noise? I think it's gunshots, and I don't want to get involved. You call the police. Whatever stress they were feeling dissipated. Right? So maybe that first portion you might be able to get in. Right? But that second portion, right, clearly you're going to find that at some point they're not stressed out at all.
And of course, what was that sound? I think it was gunshots. That's probably a present sense impression, right? Because you just heard it before you describe it. The gap is just long enough for them to say, what was that?
So, that's going to be one of the things that you got to battle. The context of all of it is, right? What are these guys talking about? I heard one person say, "Hey, what happened?" Right? Yeah, that car, they were hit by a red car and the driver ran away. Okay, what was he talking about right before that? Having a hot dog and, hey, you want to go get a hot dog and a Coke? And, maybe he wasn't under the stress. Maybe his preceding conversation indicates that when he said this, that stress was long gone. So just kind of keep in mind that there's this period, and you're looking at the immediate facts of when it was said, but you're also looking at what happened before and what happened after to give it some context to either support or refute it, depending on whether you want it in or you don't.
Right. And there's no hard, fast, anything rule about how long someone is under the stress of whatever they saw. It depends on what they saw. It depends on their psychological and emotional reaction to it. You can imagine that somebody who sees something that wouldn't be all that upsetting to most people just freaks them out. And hours later, they're still just like shaking their head and just, I can't believe I didn't know it, right? So the context, the declarant, all of that matters. If you want to get it in, you got to develop whatever shows that they're still acting under the stress of the incident that they saw or observed.
You guys get it? Got a lot of friendship points on that one.
Yeah.
A lot of points. So,
I'll take it.
Three quarters.
who wants to do 14.3? Okay.
Okay. Assume the same factual circumstances as in problem 14.2, except that Denise has filed a separate lawsuit against Bob for breaching a verbal agreement to buy Denise's car for $25,000. Bob denies that he agreed to buy the car. In the breach of contract suit, Denise calls Marissa, the ambulance driver, to testify that when Denise was in the ambulance, still writhing in pain, Denise said, "Oh my God, even though I'm in agony, I remember that Bob agreed to buy my car for $25,000. Is Denise's statement to Maria admissible in Denise's breach of contract suit against Bob to prove that he agreed to buy her car for $25,000? Okay, so the present sense of impression would require that statement that Bob had agreed to buy the car for $25,000 be related or explain the event or condition.
What she was feeling. Remembering that Bob agreed to buy her car is not something that she's
it wouldn't
feeling.
be there. So wouldn't go in for present sense impression. Cited utterance, a statement relating to a startling event or condition. Well, it's not related to the current event. Then existing mental, emotional, or physical condition. Well, she can make an argument that it goes to her maybe mental condition because even though she's withering in pain, at least she has $25,000 to rely on. Maybe ease the
Except, what's the exception on that rule?
a statement of not including a statement of memory, and it's.
And what's
I
the
remember
statement?
that.
I remember,
Mhm,
right?
yeah,
It's the I remember that takes it out of that exception,
Okay.
right? And this is an extreme example, but let's say you're in your house,
Mhm.
Denise is in her house and she's talking to a friend, and she says, man, my back is just killing me ever since that car accident, right? She's talking about presumably her then existing physical pain.
Mhm.
I'm feeling it right now, as opposed to, man, I remember my back hurt for like a month after that car accident.
Mhm.
Right? Are you feeling it right now, or are you telling us what you felt following the accident? Right? If you're going to a memory, that's not admissible. Right? It has to be something that you were then experiencing.
Unless you're talking to a healthcare provider.
Unless you. So, you guys see that?
Yeah.
Okay. You know, those are the type of exceptions you got to keep in mind, right? And when you're dealing with the then existing mental or physical state, it's tricky, right? Because my then existing state is, I remember my
Yeah.
arm hurt.
Right.
That's how I'm feeling right now, is I'm remembering that my arm really hurt. But is your arm hurting right now? No.
What if she had said like, oh my god, even though I'm in agony, at least Bob agreed to buy my car for $25,000? Is that still memory because they had made it contract?
Well, is it an existing mental condition, emotional condition, or physical condition?
I would say more mental, if that were to be an argument.
Right, but she's not really talking about her mental. She's not saying,
I am
You know,
so relieved that I'm excruciating agony, excruciating mother pain, but I am soothed by the relief knowing that I sold my car to Bob for $25,000.
Okay.
Yeah, nice try.
yeah. You know, you're gonna have a hard time getting that one in,
Yeah.
right? Primarily because it comes out of left field,
Mm-hmm.
right? It doesn't pertain to anything. No. So, all right. 14.8. Okay.
Bill is charged with threatening Jim. The prosecution calls Jim to testify that when he saw an email message from an unidentified sender telling him to prepare to die, Jim immediately told his roommate, "Oh my God, this must be another threat from Bill." Is Jim's statement admissible evidence to prove that Bill sent the message? Well, it is a excited utterance. He's feeling fear, so the present could be argued as the present sense of question. But there's something, I feel that there's something that doesn't fit. I mean, to prove it's Bill, it's not really to prove that it's Bill, it's just another email message.
All right, well, let's, here's the first thing you gotta talk about, right? And don't be afraid to break these things up, right? The question is Jim's statement admissible evidence to prove that Bill sent the message? Okay? You really gotta identify two different things, right? Ultimately, you're talking about Jim's quote, "Oh my God, this must be another threat from Bill," but you're also necessarily have to talk about, prepare to die, right? Those are two separate analyses. And when you see that, you've got to be able to identify the statement and the declarant to go through the analysis. So, for argument's sake, let's start off with, he opens an email, unidentified sender. So for our hearsay analysis, unknown declarant, prepare to die. hearsay.
Prepare to die?
It's an assertion.
What's the
Tells the
fact?
future.
What's the fact?
It's a threat, future threat. I thought about the future.
No, you're right. Okay, when you're talking about something in the future, you're not asserting it for the truth, right? You're saying that's gonna happen way out then. So it's not an assertion of fact. It's a statement of prediction what's gonna happen in the future. Okay, and then you started to.
But even if you consider it somehow, something that's happening right now, right? I mean, the important thing is the words were spoken, right? How do you prove or disprove prepare to die? It's not even a kind of like a factual assertion. It's intended to scare you, and at least impliedly a threat, right?
Yeah, I think that's where you were going. You said it's a threat. So remember we talked about what else is not hearsay? Words that have independent legal
Yeah.
meaning, right?
They're important just because they were spoken.
Right. And in these, right, the threat is, can you imagine you're trying to prosecute somebody for a threat? And did they threaten you? Yes, they did. What did they say? Objection, the threat is hearsay. Right? How did we get in the actual words that were said? Right? So under your first analysis, right, do you have a declarant? Arguably you do. Do you know who it is?
No.
You don't. Do you need to know who it is for your analysis? No. Your declarants don't need to have a name. Right? You need to be able to just say, somebody said it. And you could jump through this probably doesn't even meet the definitional standard of hearsay. So prepare to die probably comes in, but now, oh my God, this must be another threat from Bill. That's your statement. Your declarant, Jim. He's telling his roommate immediately after he reads it, and you say,
It's a present sense impression, and it's also, it could be argued as excited utterance, because he's afraid. And it could also be an existing emotional condition. Because of fear.
okay, well, the first thing I would argue, okay, and this is just, let's fast forward to the final. Okay, if you're asked a question like this, you've got other objections you can make, right? That this is speculative, there's probably a lack of foundation, right? How does Jim know this is Bill? He's just saying, oh, it must be from Bill. How? It says it's unidentified. Why would an unidentified email come from Bill? Right? There's stuff missing there. But since we're talking about hearsay, let's then go on to hearsay. But for purposes of cumulative final, and when you take the bar exam, they're going to want you to demonstrate everything. Hopefully you see that there's other objections to that statement. Okay. But if they object to hearsay, you say,
It's the objection here, so I say, but Your Honor, it's a present sense impression, because he reacted as soon as he saw the email, right after the email.
okay, and what's the event that
The event or the
condition that
is
he's describing?
receiving an email as the event.
Okay,
It's a.
you know, that's arguably that's what he's saying. And what if somebody wanted to play devil's advocate, what's the defense gonna say?
I thought we were talking about the statement where Jim told his roommate, "Oh my God, this is a threat for." I thought we were past the email.
No, we are, but his statement is he's talking about that Bill must have sent that message, right?
Right. Okay.
And is it admissible to prove that Bill sent the message?
Well, the defense would just say that you can't. I want to say you can't prove that. It says in the fact that it's an unidentified message. So
It's speculation. Oh my God, this must be another threat from Bill. If he's describing an event, that's where it gets tricky. What is the event? He's not describing reading a message. He didn't say, "Oh my God, I gotta prepare to die." He said, "This must be a threat from Bill." Right? If I'm arguing, I'm saying he can't know that. How does he know it? How does he know it's a threat from Bill? Right? What did he perceive that led him to that conclusion? Right? And whatever it is, if it's an unidentified email, whatever it is that led him to that conclusion, it's not this event. Right? Something has happened previously unrelated to
All
this,
those other emails he got.
right, that led him to this conclusion. So arguably, he's not describing what he perceived here. He's explaining what he's concluded over the basis of a number of perceptions. Right, so I would object, not a present sense impression. Judge agrees with me, not coming in. And you go to your next exception. What do you
It's an
think?
excited utterance. He's expressing the fear. He's got such a strong fear of this bill.
Right?
And he never receives any other emails.
That he's acting under the stress of that, right? You got the same issue, right? Is he talking about the startling event? If he is, how does he, right? Or is he inferring other events in this statement? That's the rub, right? This statement, under these circumstances, he's adding more than he could have possibly perceived. Right? If this is a one-off event, an unidentified email comes through, "Oh my God, it's got to be Bill." Random, how did you come to that conclusion? "Oh, well, Bill did this, and this." Right? Those are not events that he's acting under the stress from. See, that's because there's more to this. That's the problem you're going to have, getting it in as any of the spontaneous statements.
Can I ask a question about that?
Sure.
So if it was signed Bill, but not Bill's real last name, it was just a Bill, could you argue that more likely than not it is Bill? You don't know his last name, so it's not really, you can't be sure it's that Bill.
But you're still going to have the same problem. He's not describing what he's perceived. He's not describing a startling event. He is describing a conclusion based on other stuff, right? More than these facts give you. And what gives these contemporaneous statements their reliability is exactly that. You're saying it as it happens. You're saying it while you're stressed. You don't have time to think. You don't have time to reflect. You don't have time to make something up.
And so if you're the proponent, you say, he responded as soon as he saw the text of the email. It was an honest, immediate response. He, while under the stress of getting this threat, immediately thought, that's from Bill. That might work.
So that you,
So your first argument would be that this isn't the present startling event or condition, this is from
if I want it out.
If you want it out, yes.
Right, if you want it in, Trish, all of your arguments are exactly the arguments you're gonna make if you want it in. Okay? It's usually not that easy. and if you're the one that wants it in, sometimes all it takes from the other side, objection. Hearsay. Well, Ms. Trish, you want it in, how's it come in? And the defense, your opponent doesn't even have to explain why they think it shouldn't come in. The burden's on you to explain, well, why should it? You know? And I'm just telling you, those are,
Yeah, and it's so quick, you have to, I understand what you're saying.
so you've got to be able to not just know the exceptions, but then put the exceptions into play. Okay? And kind of keep in mind that, if you're on the other side, don't just accept it. Objection, this is hearsay, Your Honor. Present sense oppression. Okay, well, I didn't think about that. Guess it comes in. No, don't just, right? You have the ability to analyze it too and say, no, let me tell you why that exception doesn't apply. So too often it's people just give up. And I think they give up because they don't have an argument to make. They can't think of it. They don't know the rules. They don't know what to say. And so they just.
They're not quick on their feet, because you have to be doing this while the witness is on the stand or
Right.
what have you. You have to be quick on your feet. And
Right.
Seems like it'd be really difficult.
Well, the key
to know
is
the rules.
know the rules and be prepared. What happens way too often, right? You're my witness, right? I call you and I ask you everything I want, and then, okay, counsel, you're witness, and then while you're questioning them, I'm reading the reports and the questions for my next witness, right? And I'm not even really paying attention, right? And it's like, oh, wait a second, well, objection, Your Honor. And then they say, what? Who said what? Right? And you see it, they just don't pay attention, right? If you're prepared and you're ready, then you can give every question, every answer, your undivided attention, and then you're much more in a position to make those objections that you know. And if you're just not paying attention, and too many times they just don't, right? They're prepping what's coming next. I'm done with you. I mean, let's go what's next. And they're not paying attention. So we got 1414. Okay.
Okay. Mary Sue Williams of 165. Mary Sue Williams for personal injuries growing out of an automobile accident. Which of the following potential items of evidence should the judge receive in evidence? Number one, prove that she was driving carefully. Mary testifies that minutes before the accident, she told Ed, the passenger in her car, that I'm always afraid of getting a speeding ticket on this stretch of road. Out of court statement. It's really a statement offered for the truth of the matter asserted. I think she was just making a comment.
No, she wants the fact finder to believe that it's true, that she's always worried about that, and therefore she's not speeding.
She's driving carefully, right? So pay attention to it, right? If you read this, what does number one say?
The minutes before the accident.
Right, to prove that she was driving carefully.
Right.
She wants to offer this. Okay? Does it do that?
Is she to drive carefully, she perceives, actually, it does.
Yeah, yeah. If the jury believes that you're afraid of getting a ticket, they're probably gonna think you're not speeding and you're driving more carefully. Right?
Right.
So it is being offered for the truth. She does want the jury to believe that she's afraid of getting a ticket, and she wants them then to infer from that she was driving carefully. So if it's hearsay, how does she get it in? Can she get it in?
Well, this is before the accident.
Right.
So this is. Is it folder 803 and 3, the existing mental, emotional, physical condition?
Sure, and what's the elements for that?
So a state of the declarant's then existing state of mind. Her fear of getting speeding tickets.
Right, look at 559 at the bottom.
So a statement identifying a currently existing state of mind, emotions, sensation, or physical condition is admissible to prove the fact that produced a state of mind only if it is relevant to issues surrounding the declarant's flow. It's relevant to show that she's driving cautiously.
Right. So is she talking about her concurrently held state of mind?
Yes.
Yeah.
Yes.
It's always
That's what
afraid.
she's thinking about right
I'm
now.
always afraid on this road that they're gonna get a ticket, right? Yeah. And it's gotta, just put on a basic level, just kind of keep in mind, it's gotta be relevant to the case and it's gotta be relevant to the issue. It is, right? They're offering this to prove that she was driving carefully. Okay? So just kind of walk through it. And 2.
To prove that she was driving carefully, Mary testifies that minutes before the accident, she told Ed, the passenger in her car, that traffic cops like to hide in driveways along this stretch of road. And this is kind of similar to number 1.
Sure.
She's speaking about her state of mind. It is relevant to the fact that if she knows that cops are driving on that stretch of road, she's driving more carefully.
What's her state of mind in number 1?
She's afraid of getting speeding tickets.
She's afraid. I'm afraid. I think I'm gonna get a speeding ticket. And now she's saying, cops always hide, in driveways along this stretch of the road. So what's she describing there?
By the way, is this being offered for the truth? That cops always hide? Anybody?
Truth of matter, sir.
No, doesn't matter whether cops, great. Whether cops always hide. She's offering it for what she's thinking.
Yeah.
So your first argument would be
Offered for truth.
not offered for the truth, not hearsay.
Right.
Yeah, well, it's sort of offered for the truth of what she's thinking.
But she's still, right? If you think cops are hiding down this road to catch you speeding, you're gonna drive what? More carefully, more cautiously, right? This goes to show,
But you may want to start out by saying, Your Honor, this isn't hearsay. We're not debating whether cops actually hide or not.
Okay, so number 3, to prove that William was speeding, Mary testifies that minutes before the accident, she told Ed, Passenger in the car that I'm really afraid that one of these speed demons is going to hit us. Okay. So statement speaks on her current emotional state of mind, and
what is her state of mind that she's trying to express that?
she's saying she's really afraid.
She's afraid that speed demon's gonna hit her. Is that relevant to prove that William was speeding?
Yes.
Sure.
She's
I mean, relevance is just a little tipping, right? It's relevant. You know, is it enough to get it in? Because keep in mind, you're gonna come under all of this with the 403, right? Right, she's not saying, I'm really afraid that car that William's driving is gonna hit me, not yet. And now she's, one of these speed demons is gonna hit me. Because keep in mind, she's afraid, she's cautious, she knows the cops are lurking in any of these driveways and people are probably passing her, going in and out of traffic. She describes them as speed demons. Do you let it in as a present sense impression? Oh, I'm sorry, as a then existing state of mind?
I thought it was.
Yeah, she's saying I'm afraid right now. Arguably it is.
Number 4, to prove that the injuries caused by the accident were still bothering her 1 month later, Mary calls Henry to testify that when he visited Mary a month after the accident, Mary told him that my back is really killing me. It hurts me every day since the accident.
That sounded familiar when I said it earlier.
Yeah.
So there's sort of two statements in here,
Well,
right?
she's saying, so my back is really killing me.
So that could be a
presence
sense impression or
then existing emotion.
Right. either one.
And then
But what about the part of, what about the rest?
it hurts me every day since the accident.
That's not a present sense impression.
It's a memory of relief or
Yeah, it's not how I'm feeling now.
Mhm.
It's not what I'm sensing now.
Right.
Is there some other way to get it in? Who's she talking to?
she's telling me to edit. Oh no, sorry. Henry.
Talking to who?
Henry.
And who's that person?
Someone that visited her a month. Oh. Who is? Someone that visited a month after the accident. So it pertains to the accident though, because the pain is from the incident.
Right, but if you focus on the exceptions that we've covered so far, right? Arguably, it's a present sense impression. My back is really killing me right now, right? Depending on how she's talking about it, is it an excited utterance? I don't know, right? Is she still under the stress of that event? Right, that event happened a month ago. Right? Probably not. Is it a present state of physical condition? Yeah. My back's killing me right now. Right. So you've got those exceptions for the present. It's hurt me every day since the accident. That's projecting back, right? Is she feeling that pain that happened yesterday or the day before or a week before or right after the accident? She's not. She's not describing what she felt each of those days. She's remembering what she felt. And can you testify to a memory of a physical condition?
No, I'm not under number 3.
You can't. So anything else you got?
I can't remember.
Right, so does it all come in, does it all go out, or what do you do?
What, isn't it consistent with her former testimony?
What?
Oh,
What former testimony?
was,
But clearly, the part about what she's feeling right then comes in. Right?
Right.
The first part of the statement.
so you, oh, that's what you're asking, so.
My back is killing me.
That comes in. for
Yeah,
the second portion.
That's a present sense impression, and it's how she's feeling right then.
So the question gives you this long statement. Here's a quotation mark, here's a quotation mark. Objection, hearsay, does it come in, does it come out? Don't be suckered into that bet.
Right.
Right? Well, Your Honor, clearly this sentence comes in. I've got multiple exceptions that lets it come in. Her saying, my back is really killing me, is coming in. As for the second portion, let me tell you why I think it should come in. If you're gonna exclude anything, you exclude that second part, you don't exclude the whole thing. So when you're viewing these, any statement can be broken down into parts. Any statement. And if part of it's better than none of it, argue to get the part in that helps you and give up the rest. Right? Would you like the jury to hear that, yeah, it's hurt me every day since the accident? Sure.
Yes.
Yeah. But if you don't have a way to get that statement in, cut it loose, because you definitely want them to say, it's still hurting me right now. And then you just ask the jury, come on, her back is hurting her a month later. Right? She's had to deal with this pain for ever since the accident. Right? So you can get them to conclude the others part of the statement without them ever hearing.
Could you get it in for the word statement made for medical diagnosis or treatment?
Yeah, if she was making it to a medical professional.
Oh.
And that's why I was saying, who was she talking to? Right? What do we know about that person?
Okay.
Could be your best friend, happens to also be a doctor.
Yeah.
Right?
So, could you answer it that way?
Based on what we know.
This says Mary calls Henry to testify that when he visited, right, not knowing who Henry is, if Henry were a medical doctor, this would qualify under this section. Right, and then right now we're looking at each other, we're like, that's
Henry, what the?
That's a really good, you're hitting everything.
Yeah.
Right? So right, it doesn't tell you that. So don't go chasing down too many rabbit holes, but it doesn't tell you it's not. So you could, if you got extra time and you just want to impress, assuming Henry was making a medical risk.
But if you've got a couple paragraph question and somewhere in there it mentions that somebody is a nurse practitioner or something, that wasn't in there just by accident. Right?
And lastly, number 5, to prove that William was speeding, Mary calls Henry to testify that when he visited Mary a month after the accident, Mary told him that my back still really hurts from when that guy William was speeding and ran into my car.
No objection, hearsay.
Quick question before I analyze this. Is it useful for me to break this up as well, or?
Yeah. But some of it is clearly, or it seems inadmissible hearsay, and some of it, like how my back is feeling right now.
Yeah, so that's, that is the present sense impression. Not sure about excited utterance. And then that's also her then existing physical condition exception.
So let me ask you this. Mary was hit by William in a car. right? Stressful event, right? Stressful condition. And we know that statements that declarants make while still under the stress of that event come in as an excited utterance. What if, in talking with Henry about her pain, she remembers the accident, she starts reliving the accident, she starts crying, she starts shaking, she starts clearly demonstrating physical manifestations that she is under the stress of this event. Can you have an excited utterance a month after the fact? If the statement is relating to the event and you make it while under the stress of that event.
Well, you're saying that that emotion came up and it's relating to the stormy event condition, and then once again they're under that stress. Maybe, yes.
What do you think?
The rule is not clear on this.
Did that added that part?
It says the excitement that it caused, but it doesn't say caused at the time or now, presently.
It's gotta be, you got excited by the event, not by remembering the event.
See that?
If you're thinking back, reflecting about it, and oh my God, I can feel the pain right now. And really get worked up and emotional and you're crying and all that, you're upset not by the event, but by what you remember about the event. It's a really good try though.
But you can argue it, right?
It can't hurt to try. It won't work. Well, you never know.
You never know.
You get me when I was a judge for 6 months, I never thought of it that way.
That sounds pretty good.
Yeah.
And that's the other side thought about it? Nope.
No.
I don't.
So do they think, hey, that's not the event, that's the memory of the event? No, they don't. They're looking at the rule going, well, it doesn't, yeah.
All right, 1419.
Okay, prove possibilities, or possible. Jerry is charged with robbery of a small convenience store. Robbery consists of taking the property of another through means of force or fear. Which of the following out-of-court statements could the prosecution offer to prove that the robber used force or fear? Choose as many would be admissible. So 1, Tom's testimony that I saw the robbery and heard the clerk say, please don't shoot me.
And?
Yes, because
it's not the state, well, first of all, is it an assertion?
It's offered as a truth or assertion.
Is it an assertion?
I would say yes.
Why?
Yes, because
What's being asserted?
he saw.
Oh.
Okay, here's what you gotta keep in mind.
Sorry, let's distinguish the two statements.
Okay.
Is the statement by the clerk an assertion?
Oh,
Right? Tom's testifying.
Yeah, Tom's on the witness stand.
Yeah, so Tom is saying,
So of course he's
I
asserting
saw
what he heard.
everything, and let me tell you what I heard.
let me tell you.
So that hearsay is what he heard.
So is it an assertion by the clerk? Please, what was it? Please don't.
Don't shoot me.
Please don't shoot me.
Is that an assertion?
Okay. Well, then it would be no.
Yeah, because you can't I guess you could say, well, it's true in the sense that she didn't want to get shot. But it's really more of it's a request. It's a plea, it's a plea. It's not really an assertion of fact.
On a certain day, don't shoot me.
Okay,
But even if you said, you know what, yeah, it sounds like an assertion, how else could you get it in?
you can get it in by the present sense impression, wouldn't it?
Well, or is it maybe I'm not sure what she's presently sensing other than fear, I guess. But it pretty clearly indicates what her then existing mental state was, right? She's afraid that she's gonna get shot.
Okay. But then it would be the then existing mental, emotional, physical
Yeah.
condition. Okay, okay,
In effect, she's saying, I am scared witless
okay.
because I think I'm about to get shot.
That would be the mental feeling. Okay.
But by far, your best argument, your best argument on a hearsay objection is always, it's not hearsay. That's always your best argument. If you can get it out from hearsay, we don't
The
need
rest
to,
doesn't matter.
doesn't matter. That's always your best argument.
But
Okay?
don't let that dissuade you from making another argument. If it were found to be hearsay, then it's admissible because present sense impression and what her current mental state is.
Okay. So, now two, Tom's testimony that as soon as the robber ran off, I went to check on the clerk, who told me that I was really terrified that I was going to get shot. So that would
Okay,
be.
so again, is this an assertion by the clerk?
Well, she was afraid, so I think I'm getting confused on assertion. So,
This sounds more like an assertion of fact, right?
right.
Because she's
I'm
stating
she's
what
telling
her,
him.
what her emotions were.
Right. See, in the first one, it was, please don't shoot me, but he heard it.
Yeah.
Right, okay. I see.
Either way, he
Okay.
hears it,
He heard.
right?
This
But
one-
what we're trying to focus on is the statement by the clerk. Is that an assertion?
Okay,
In the first one, you could say it's really not, it's a request, right? Can't really say that with this. Now she's like asserting the fact of how she felt.
okay,
Right.
And do you see that? In the first one, you have to assume that she meant something,
uh-huh,
right? We're assuming, we're inferring fear, right? We're inferring that she's scared she's gonna get shot. She's not asserting that she's afraid. She's not asserting that she thought she was gonna get shot. We have to infer that from her statement. There's no assertion there. As compared to here, she's telling you,
This is how I felt.
I'm
Okay.
afraid I was about to get shot.
Okay, okay,
So, but let's not jump immediately to the then existing mental condition, right?
uh-huh,
Although it might clearly fit under that. Present sense impression,
yes,
maybe. We usually don't talk about senses as something that's coming from within us, like what's going on in our brain. It's usually what you feel, what you hear, what you taste, what you smell, right? But maybe present sense impression, I'm feeling afraid.
okay.
How about excited utterance?
I would say yeah.
Damn right, she's still upset about it,
Mhm,
okay?
mhm.
And by the way, on that present sense impression, she said it almost immediately after the
Right,
incident,
it's
right?
kind of-
Because the guy runs to help her. Excited utterance? Sure,
Yes,
she's still freaked out by having a gun in her face. And of course, she's describing her then existing mental state.
okay,
And, you know, if you want to try to keep it out, you quibble and you say, well, it's not, she didn't say she's afraid right now. She said she was afraid a minute ago. So it wasn't then existing. Yeah, and good luck with that argument.
It's gotta be one or the other, right? You're either talking about your present sense of what you impressed in, or you're excited because of the stress, or you're describing how you feel right now, right? And
Somehow it's admissible.
yeah, it's not trying to focus on it. It says I was really terrified. Does anyone here think that she's not terrified if she's telling him this right now? Right.
But I think the important thing to contrast the two statements in the previous one and this one is, this one's pretty clearly an assertion.
Okay, 3, Tom's testimony that as soon as the robber ran off, another person and I ran over to check on the clerk. The other person said, "Oh my God, the victim must have been terrified." So if it's an assertion, I would say no, because this is just, he's just speculating, he's just thinking that this is what it's speculation.
Okay, but is it really speculation? Because he saw what happened. He observed how the clerk was behaving, saw the fear in her eyes, saw her hand shaking, saw that a guy just stuck a gun in her face. So is it really guessing, or is it, you know, sort of?
Well, with all of that, I would say no, then it's, he's saying, yeah, that he's witnessing that she was terrified, so it would be. But,
See that, and that's something you're gonna wanna explore, right? If I'm the defense, objection hearsay, well, you know, it's this, and I got this exception. Okay, well, you got, you know, personal knowledge issue. How do they know?
How do they know?
How do they know
How
that?
does he know what was going on in the other person's head?
Right, then the prosecutor's gonna ask, you were there, right? Yes, I was. Well, what did you see? What did you hear? I saw a guy with a gun sticking in her face, and I heard her say, please don't shoot me. Right? And then pretty soon this onlooker is giving the same testimony Tom gave. Right?
okay.
So.
But yeah, one objection might be, he's guessing at what was happening in her head, right? Suppose you get past the guessing.
Okay, so then again, but it says as soon as the robber ran off, so it would be, well, present sense impression? As soon as the robber ran off, because they ran over as
So it
soon-
happened immediately
It
after,
happened
right?
immediately, right.
So is there a present sense impression? Yeah, maybe, because you're sort of reaching a conclusion from what you saw.
Mhm.
So maybe that.
Excited utterance?
Excited utterance?
Yes.
Yep.
Mhm.
Yeah, you're probably still stressed out.
So,
But you're not describing your mental condition, right? You're describing somebody else's mental condition, so that exception doesn't work, does it?
No, because you really don't know what that other person's.
Well, you're not describing what's going on in your head,
Right.
even if you can guess fairly well. It doesn't qualify as the then existing mental condition in your head.
Okay, so that's what that, yeah, so he's describing what the victim is, what he's thinking the victim is. Okay, so for Tom's testimony that the day after the robbery, the clerk said to me that I was really afraid that I was going to get shot during the robbery.
Okay, again, don't worry about what Tom said,
Okay,
is what the clerk said an assertion.
okay, so this was the day after.
Right.
So,
So is that an assertion? Sure it is.
it's an assertion.
It's what I was thinking, what I was feeling, I was afraid.
Right, okay, so with her, it's an assertion.
So it's hearsay, right?
It would be hearsay.
Present sense impression? No. If it's the next day, it's pretty clearly not immediately after the
Okay.
robbery. Excited utterance? Have we got any indication she's still whacked out about
Yeah.
what happened the day before?
So that the timing would be the factual statement for the courts, right? Wouldn't that be?
Yeah,
so
but-
it would have to-
But what do you think? Are you still excited about what happened the day before?
Yeah, because it would be a startling event, so you have.
You
your
haven't
gun
calmed
pointed
down?
And your gun.
You haven't calmed down in 20 hours?
No.
Okay.
Not me.
Okay, in my courtroom, sorry.
A year after, I'm still.
And don't get me wrong, because I vividly remember the testimony of a bank robbery victim, a teller who never went back to work after that day because she was so freaked out by having a gun stuck in her face. And when she's on the witness stand and the prosecutor pulled the gun out of the evidence bag, she burst into tears.
Oh.
So was she was still excited, she was still upset, but it was by the memory of what happened, okay? So,
Okay,
anyway.
okay. All right. So
And it
that's-
was quite fresh in her mind, obviously.
So then that would bring to the mental state, the memory of it.
Then existing mental conditions, no, the mental condition from yesterday. So far we haven't
Oh,
found
that's
an
right, it's
exception.
not remembering the event, that's what it is, okay.
Right.
That's right.
So suppose she says, I am still freaked out about, right now, I'm like freaking out over what happened yesterday. Then existing mental condition, I'm still afraid of that mother bank robber who stuck that gun in my face. I am still petrified that that gun's gonna go off. Well, then existing mental condition?
It can go either way, because she's still kind of remembering, right? But she got excited about the event.
Here's what I would argue if I were trying to get it in. If she's still afraid the next day, she was afraid at the time. So her then existing mental condition, I am still petrified as I stand here right now, is a statement of her then existing mental condition, and it is powerful circumstantial evidence of how she felt the day before.
Okay.
I guess that'd be technically circumstantial, right?
It's strong.
Yeah, we're very
That's
strong.
strong.
So then it has 5, Tom's testimony that I saw the robbery and heard the clerk call out to me, stay away, he's got a gun and he's going to use it. So this is Tom's testimony, right?
Right.
I saw the robbery and heard the clerk call out to me.
Is that, okay, so part of this is clearly an assertion, right?
It's assertion.
He's
Yeah.
got a gun
He's got a gun.
and he's going to use it.
Mhm.
Let's assume that the assertion, okay, he's got a gun, that's an assertion.
Mhm.
He's going to use it.
No.
Maybe that's not an assertion of fact, because it's kind of like drawing an inference from what the hell is going on. But let's say that you say, yeah, that's covered by the hearsay rule. How might you get that in as an indication of, well, how might you get that in? What exception might apply?
Well, I would say present tense or present sense.
Yeah, she's describing, or the clerk's describing what he or she is seeing right then.
Right now.
Yeah.
And excited
Excited utterance?
Yeah.
Yeah, could be.
So,
Then existing mental state, pretty indicative that she's afraid or he's afraid that the dude's gonna use the gun.
yeah, so it's at the event, yeah. So all three of them would come in, wouldn't it?
And if you go all the way back to the argument His Honor made the last time, I think that applies as well, right? You could say, it's not being offered for the truth. I don't care if the guy had a gun and was about to use it or not. Her saying that, her thinking that, I'm not offering to prove he had a gun. I'm offering to prove she was afraid. And those words are circumstantial evidence of her state of mind, which was fear. I'm not offering it to prove that he had a gun. I'm not offering to prove he was going to use it. He's not charged with attempted murder. I'm offering it to show her fear,
Okay.
right? Which that is circumstantial evidence of her fear, that she would say something like that. If you're the defense, she wasn't scared. She was taking charge. She was like, hey, you guys stay away. I'll handle this. Right? But you want to be able to think of all of those. And remember, when you're doing your hearsay analysis, I know when we get into the different problems and the different sections,
they're focused on whatever that particular exception we're talking about. Your analysis should still be, is it hearsay?
Yeah.
Right, and in the back of your mind, you're thinking, right, is there an exclusion? Right? Now, does one of these exceptions apply? Right? And let's say you come to the conclusion, yeah, this is a present sense impression. She's describing what she's perceiving as she sees it. You're still going to come under that with a 403 analysis, right? What if everybody says, all the witnesses say he doesn't have a gun, never had a gun. He came in and said, give me all your money, in a really mean voice. And she said, everybody stay back. He's got a gun, he's gonna use it. Prejudicial, right?
Yeah.
I'm not offering it to prove he had a gun, wink, wink, right? I'm offering it to show she was afraid, right? Might the court say, yeah, I'm inclined not to let that statement in because of its prejudicial impact, even though it's really strong circumstantial evidence of her fear, I'm not gonna let it in.
She's so afraid she imagined powerfully that he had a gun.
Right. So even though you have an exception, you still got to do that balancing, see if it's going to come in or not.
So you would look at it and say, is it hearsay? Is it excluded? Is there an exception? Is there another way to keep it out 4-3?
Okay.
In about, what, 10 minutes for an essay like that?
In and out.
Okay, the last one was 6. Sylvester's testimony that the day after the robbery, the defendant Jerry told me that the clerk I stuck up yesterday was really terrified.
Ooh. Is it hearsay?
Yeah, it would be hearsay. The day,
Okay, are you sure it's hearsay?
the day after the robbery.
What's the statement? The
Oh,
statement is by whom?
okay,
Who's making the
the
statement?
robber.
Yeah. Is it hearsay if the prosecution
Okay,
offers it?
all right, so,
By definition, it's not hearsay.
okay. See,
So when you're like reading these questions, the
Like
first
the
thing you
last-
gotta think is, who's the declarant? Who's making the statement?
okay,
You guys are gonna get confused if you don't do that right up front. Who's my declarant and what statement are we talking about here? Like, for example, right, if you just look at one and it says Tom's testimony that, in quotation marks, I saw the robbery and heard the clerk say, please don't shoot me. And you start analyzing Tom as the declarant and all of that as his statement, right? You're going down a rabbit hole, right? Because Tom's the witness, right? And him saying that he saw the robbery is a hearsay, even though for question purposes, it's in quotation marks, okay? You gotta identify who your declarant is. You gotta identify what your statement is and then analyze accordingly. Okay? Now, I know it's break time, but we've covered all of our
Wait,
problems.
I have a question.
Yeah.
real quick. On the last
Real
one, looking at the definition of hearsay, so is that by definition hearsay because it's an out-of-court statement, the declarant's making an assertion, arguably, right? He's saying the clerk I stuck up was really terrified. That's asserting that the
Yeah,
clerk was
that would be an
terrified.
assertion and it's out of court. But if we didn't know anything more, yes, that would be hearsay.
Right.
Except
Except-
we know that we've carved out from hearsay certain things, and one of them is statements by the party opponent.
I think it's so difficult because you're trying to analyze.
Yeah,
Tenses, when it
Yeah, yeah,
happened, multiple people's perceptions.
yeah, who's saying?
Who said what about what,
Right.
and it's so easy to get them confused and mixed up.
Absolutely.
This one is actually pretty easy as soon as you figure out who made the statement.
Yeah.
Right? Because as long as it's a statement by a party opponent, it can be a prediction, it can be anything at all. By the way, at least in state court, you're always talking about the admission of a party opponent. It's not. The rule is not an admission of a party opponent. It doesn't have to be an admission. It's just a statement. So it doesn't have to sound like they're admitting that they committed a crime or anything else. They made a statement, it's a statement, it comes in. And don't let anyone ever trick you into thinking, well, was that really an admission or not? Because it doesn't matter.
What else you got?
So it's not hearsay because it's an exclusion.
It's not hearsay because it's excluded because it's a statement of a party opponent. Sounds like hearsay.
Yeah.
Right? Out of court statement, offer for the truth.
Offer for the truth.
But
Well, I don't know. I'm seeing looks on your faces. Look, you want to take if you want to take a break, come back in and do some more problems. We could do that. Yeah. Did you even know you just did that? I perceived it. You're like,
was that an assertion?
you're like,
No, it's not.
We also,
she's still under the stress of the thought of
the
doing
thought
more
of staying in
problems.
class.
Was it staying in class or doing the problem?
I don't know.
See,
It's what I perceived.
I do want to say how.
My mental state is
Yeah, right.
So,
It's really not as hard as it seems sometimes, because just break it down. What's the statement you're talking about? Who made it? And then, is that, first of all, is it even an assertion of fact? Okay, or any question, maybe it's an implied assertion, okay. And then who made it? And then just, okay, being offered for something out of court, being offered for the truth, carve out, exception. Yeah. And the hearsay rule sounded so easy, didn't
it did.
it? Yeah.
Piece of cake.
And there's 23 exceptions.
Oh, we're just getting started.
Yeah, we're scratching.
We're just getting started. We went over 4 of them today.
You're gonna love past recollection recording.
Okay, if you guys, hearing no, I really want to stay and do more problems. I don't know, I see Brian's look, he's like, well, I kind of do.
I think just getting the approach down, like just really practicing over and over on our own.
Mhm.
It's
Well,
very useful.
and here's what you need. Identify the declarant, identify the statement. That's going to help you decide, does it meet the definition of hearsay? And when you start getting into the exceptions, use your elements.
Yeah.
Right, the elements are there. There's only 2 elements for each of these exceptions. Know what they are, and either it's there or not. And if you have to stretch the elements, it probably doesn't fit. Okay, it's either there or it's not. Okay, and just kind of keep in mind the whole, idea of why it is that we let these in.
And notice for the first 4 of these, when the statement is made really matters. So who's the declarant? What's the statement? When's it made? Oh, it was made the day after. Well, it's probably not a present sense impression. And it's probably not an excited utterance. And it's probably not, existing physical or mental. Well, it might be physical. Anyway. The one where it doesn't matter when it was made is statements for medical purposes, right? You can do that here later.
All right, guys. It's so much fun. We'll have a lot of fun next week too. When we add to it. And you know what you guys already have? Character and opinion
Yeah.
and impeachment.
Yeah,
And
403.
oh, you guys got all of that still too, right? Don't forget it. It's just-
This is all gonna seem really easy when we talk about Crawford. You're gonna get very tired of the word testimony.
It was so really quick. I never saw.
It does, and it's funny. Maybe it's just my experience, but I know when I'm in court and I'm the attorney, I don't always, I miss things. I can miss things just like every attorney does. But it seems like when I'm sitting back in the audience,
Yeah, when you're
I don't
watching.
miss a thing.
So years ago, I was seated as a juror next to a lawyer who was a friend of mine. We had worked together for a while, long time before. Anyway, and we're in the jury box, right? And we get in panel, and so we're like, oh, crap. Anyway, so we're like in panel, and we joked later that with the lawyers, like, we could ask better questions than these guys. Well, it's a lot easier when you're not asking the questions, you're just watching it, right?
Yeah, when I'm watching, I always see
Yeah.
objection, and I would say most of them are.
My
Unobjected.
my first trial, I was literally biting my tongue to keep from objecting to the questions. And I'm like, no, that's not my job. Anyway,
Oh.
see you guys next week.
Okay.
Stay warm tonight, because it's cold out there.
Yes.
Coffee at night?
Yes.
Oh, Huh?
Was it just sleeping and drive here? I don't get it. I was even sleeping and drive here. I was like, what the hell?
When do you find out about your position?
Oh,
To get it or
I should ask Mr. Nolan if his wife knows. I'm kidding. I'm gonna give it a little bit of time. Maybe
Did they say, did they tell you?
it said to be a week, to be a few weeks.
Oh, it's probably gonna be a few weeks.
Yeah.
Especially if they're in and out of court and stuff.
Yeah. I don't know if people are doing anything, but yeah, they must be. I think they're- like, you know, when they're reading a lot and then you just get a sense of like, are they picky or are they just like, you know what I mean? They just-
right,
I think they're really
for a long time.
yeah. Maybe a week or so.
Yeah.
Yeah, if they're not next week then.
Exciting.
Okay.
I want my summer to look different this year.
Huh?
I said I want my summer to look different this year.
Aw.
Yeah. I've been working there for 3 years now, so I'm like,
You
I'm ready
work
for a change.
overnight, right?
Yeah, I'm ready for a change. I can keep a restaurant job, but there's better ones out there. I pay that way better.
Well, that overnight's